France Brevets has announced another deal. It's given a worldwide royalty-bearing license to Samsung over unspecified patents. It follows a similar deal with Sony in April. Now, terms of both deals weren't disclosed, but what's noteworthy is that it achieved the Sony deal through the negotiations, while it had to sue Samsung in Europe and the United States to get the company to come to the negotiating table. Now, Malcom Meeks, who's Vice President and Head of IP Licensing at France Brevets, does not see this as a failure of his negotiating first, litigation last approach. Malcom, firstly, talk to us a little bit about the two deals that you consummated recently, and I guess the significance of them to France Brevets.
Well, we've done two deals recently, one with Sony and one with Samsung. Both involve our NFC licensing program, near-field communications. The Sony deal was significant in that it was done with no litigation. The Samsung deal was done after litigation in both the US and Germany. And it's no secret that now getting patent licenses done it's quite difficult, so we take great pride we're able to get that done, but it also shows the validity of the program, we think.
Yes, indeed, because that's obviously the main vision and mission of your company, to achieve these licensing deals without litigation, where you can avoid it. But without mentioning numbers, because I know you can't, but can you tell us a little bit more about what the outcomes of each of these were? Because obviously, as you said, one of them you had to litigate, the other one you didn't. Was the one that you litigated more favorable than the one that you negotiated?
Well, again, I can't get into too many details, but in terms of favorability, it's generally always better to be able to get a deal done with no litigation, because everyone saves on costs. It's more efficient for all sides, but typically those involving litigations are higher stakes, so we'll leave it at this.
I see. So, if you could have done the Samsung deal without litigation, would you have? Would it have been just as good or even better than it actually turned out?
Without question, we would have done it with no litigation, if possible. That's always the goal.
Yes. Now, in view of the fact that you did have to litigate, does that challenge your mission in any way to do the best you can on the negotiation front first?
Well, I think people can differ on this, but I do think that in terms of licensing, litigation is a key aspect of that. Obviously, you don't want to have to litigate, but litigation is the backstop, in my humble view, of licensing. And so if things don't go the way you want them to go during the negotiation phase, you have to litigate to prove the strength of your patents. And sometimes you have to do that to prove that you're serious. Unfortunately, that's the case sometimes, but of course we are prepared to do that if we have to, but we'd rather obviously not.
How much more flow-on do you expect from this, now that you've secured these two deals in recent times?
Well, we now have, based on largely from the work of our licensing team, we have 3 deals done now, one with LG last year, one with Sony earlier this year, one with Samsung just recently. We've done this with successful litigation and without litigation, so hopefully what will happen is we have a significant portfolio now. This momentum will continue such that we can get deals done without having to litigate, because we've shown the market that we can, and we can do so successfully, and hopefully that will be the outcome.
Given the fact that you've been in the industry for so long, what was the starting point for the woes in the US?
For me, it was eBay, with the fact that essentially injunctions in the US are a virtual impossibility. And then from there we have the erosion of damages with the smallest saleable units, and then with the AIA and the Alice decision and IPRs. So each of these trends has consistently eroded, some would say eroded the value of patents, and I think that's a fair assessment. But it certainly has eroded the economics of trying to monetize your patent assets, because there's been downward pressure on damages, and certainly each year the cost of litigation goes up. So the value in between there has really been squeezed, regardless of really the value of the underlying patent asset. And I think that's the real problem that most patent practitioners and most patent owners have, is that trend is true regardless of the value of the underlying asset. Now, some believe that the pendulum, quote unquote, may be swinging back, with some recent Supreme Court decisions, some recent decisions in the Federal Circuit regarding Alice, where software patents was deemed to be patentable.
Yes.
And then some subsequent guidance from the PTO on that point. But for this correction, to be undone and come back to a bit more of a reasonable midpoint, I think in the US will take some time. Even if in fact the pendulum is swinging back, it will take quite some time before patent owners feel like they are really getting fair value and fair treatment in the US patent system.
The question is whether the ill effects, I suppose, of all of these decisions is going to be short-lived. That was the term a guest used earlier on, that within the year we're going to see a reversal of the fortunes there.
Look, you may see some decisions. For example, the Supreme Court decisions may come out that are favorable. You may see some more favorable Federal Circuit decisions in the near term. But in order for that to take effect, that will take years, I think. And even with the IPR process, there may be some changes with the Supreme Court decision that comes out, but overall, I think it's still going to be a quite a challenging system for patent owners. And this is to say nothing about the damages calculations and the uncertainty in terms of what actual damages are in terms of patent infringement. So it's going to take quite some time for that pendulum to swing back to what, depending on what side of the fence you're on, we get back to more quote-unquote normal levels.
So I guess you were just saying time is money. So is there an amplification of the ill effects as a result of it taking longer? In other words, are we suffering more and more damage the longer it takes for that pendulum to swing back?
Well, I think that what you're going to see, it could be good or bad, again, depending on what side of the fence you're on. I think there's certain economic factors that will come into play with U.S. litigation. If it's still more difficult to litigate and there's downward pressure on damages awards and the cost of litigation continues to rise, eventually you'll see the market move away from U.S. litigation. And what that typically will mean is that the cost of litigation should go down, less demand, so then the price should drop. And also what you'll probably see is a bit of more of a, I won't say a rush to Europe, but at least an eye-opening towards maybe there's something to do in Europe. With the UPC coming online potentially, that seems on its face to be a bit more pro-patent. Pro-patent is a bit of a relative term because you can't invalidate European-wide as well as having an infringement decision European-wide. But at the very least, people will begin to look more, I think, towards Europe and enforcement in Europe. But the problem there is we're in this gray period where yes, people are talking about the UPC, but the UPC currently is a concept. I think it's a great concept, but the reality is right now it's just a concept. It's an idea, great idea, but it's just an idea. So we don't really know, A, when it will be instituted, depending on the Brexit situation. And if it is instituted, we won't really understand how it operates and how the judges operate and how the system operates for quite some time as well. So I think we'll be in this gray period for patents on both sides of the Atlantic. We can talk about Asia maybe later, but on both sides of the Atlantic. And probably what you will see is new business models developing. We heard a lot today about collaborative business models. I think that's very, very, very true. Because if you see the number of people here at this conference, IP still matters. IP still has economic value, and smart people will find a way during this uncertain time to find ways to take advantage of that uncertainty, which that's typically when, to be very frank, fortunes can be made and opportunities can be had. But also, too, there are business models that exist that don't exist now that will exist in the next 2 years. So I think in the next 2 years, that's what you'll see. New business models that are more of a win-win, so to speak, for the traditional licensor and the licensee, if we're even using those terms.
Yes. Because in a sense, particularly with the Internet of Things requiring a lot more standardization, presumably the old way of doing things is not sustainable anyway. Would you agree?
Well, I think saying it's not sustainable is a bit strong, but I do think that it will require much more, again, collaboration. There will still be innovation entities will still want to have value for their innovation. They will still want to protect their innovation, and they will still want to find some way, and I think this is the key, some way to extract value from that innovation. And I think what may happen is the traditional stick-based model of licensing may not be the way that value is extracted. There may be other, more collaborative ways. So to say it's not sustainable, I think is a bit strong, but to say that people need to think more creatively is definitely the case.
The new normal, as I guess they were saying here today. Just before we leave the US and focus on Europe,
Yes.
Is there a risk that the longer the US delays in making these changes, and let's say there is no Brexit and the UPC in Europe goes ahead as planned, is that kind of like the natural deadline for the US to get it right?
Well, I think, I agree. I think the momentum will be against the Americans, but I mentioned this in a conference earlier this year. There is a competitive nature to the US psyche, yeah? It's true around the world, but certainly in the US. So if at some point, once the UPC goes into place, it won't be when it immediately happens, there'll have to be some trends that occur, yeah? So when politicians begin to see that, more and more innovation jobs leave the US, or there are less filings in the US, less litigations in the US, the perception is that the IP capital of the world is no longer the US, but it's moved to the other side of the Atlantic. I think that competitiveness of the US system will come out, and some congressman somewhere will say, some CEO of some large company will say, wait a minute guys, we're losing our advantage, we need to get this back, we need to make some corrections, and then it will happen. So I think in some ways, if the UPC comes online and operates in a solid, fair, smart way, which everyone thinks it will, then I think you will see the US accelerate that pendulum swinging, so to speak, and then hopefully we'll have fair and balanced policies on both sides of the Atlantic. And of course, we haven't talked about Asia, but there are many initiatives in Asia to become more like what's happening in the UPC. In other words, make it more, again, patent friendly is a relative term, pro-patent a relative term, but certainly more transparent in how enforcement occurs, how to find value. So the US is actually going in the opposite direction, while the rest of the world seems to be going in a more balanced direction.
Right. So what did the Europeans do right?
Well, I think certainly, as it stands now, the system in Germany, and we've used the system in Germany, we've litigated in Germany, and we've been quite pleased with the results, not just because we've been successful, because the judges are actually quite balanced, they're very thorough, maybe even more thorough than I may have liked them to have been in certain situations. But that system is quite good. And if that system, as part of the UPC, is rolled out across Europe, all throughout Europe, that is going to create a very comfortable and smart, solid system in which to enforce or invalidate. And the fact that it would be European-wide means that instead of going to each individual country and costs and legal systems, et cetera, there's one throughout all of Europe. Now, of course, with the reward, there's always a risk, and the risk is, yes, you can have a European-wide verdict in your favor for infringement, but you can also have your patent invalidated European-wide. So, so to answer your question, I think it's because the system seems to be solid, fair, balanced, transparent, and really looking to find true value in the patents and not necessarily biased in any way, which, to be very frank, is how it feels currently in the US.
Yes. In view of the fact that the Americans are so competitive, I think we all know the competitive spirit. But when you see the amounts of money that started to be exchange hands, the litigious nature, wasn't that the source of the abuses as the lawmakers saw it, which then led to the reactions that we saw also in the Supreme Court? Whereas, as we heard Boris say at the panel this morning, the Europeans never went down that track. So can I put it to you that it was actually all the players, including the intermediaries, such as yourself, who actually were kind of responsible for the problems in the US, that you touched off that wave of the court decisions that have proved to be so detrimental to your cause?
Well, look, we're all part of the ecosystem. So we all had an impact on the ecosystem, whether you were, at the time I was practicing patent litigation at a firm in DC. So yes, there's, again, we talk about the pendulum, you hear it so often. The pendulum swung in a way such that many in the business community, the judicial community felt like the patent system is, there are no limits, there are no bounds to it, and we need to pull it back. And there was also competitiveness in competing outside of the courtroom and outside of the marketplace and competing in the lobbying efforts that was very successful to get that pendulum moved. Now the question is, did it go too far? And it's true, in Europe, you will not have a very, very large damages award. And I don't think that's going to change with UPC.
You don't even have a pendulum.
Right, but you do have the injunction. But of course, with the injunction, you have to put up a very large, significant bond. At least in Germany, I think it'll be the same in the UPC. So that is another way to curb that abuse. You don't just get the injunction, you have to put up real money in order for that injunction to be imposed before the appeal. So, but to answer your question, I cannot deny this. And there was a strong reaction. Some would say there was an overreaction in the US, and it's going to remain that way, I think, until some other lever somewhere is pulled that will cause it to come back. And I think that other lever is starting with the UPC, and maybe starting with some court decisions coming out in the next months, but we'll see.